afternoon, everybody. My name is Miss Ntsoaki Queen Mokhele. I'm a level 1 civil practitioner practicing with the Legal Aid South Africa, Bloemfontein local office. And I work mainly with deceased estates. This is all I do, day in, day out. So I am really and well knowledgeable when it comes to wills, as I work mainly with deceased estates. First off, I would like to give you a definition of what a will is. A will is a legal document that the testator uses to express his or her wishes as to how his assets should be distributed or who they should vest to in the event of his or her death. A male person who is drafting a will is commonly known as a testator. A female person who is drafting a will is commonly known as a testatrix. So for the purposes of this presentation, I'll keep referring to a testator as it is the commonly used name as opposed to a testatrix. Okay, one can ask, why should one have a will? The answer to this would be that it is an advantage for one to have a will for the basis, mainly because we need to know the wishes of the testator of what should happen in the event of his or her death. So we need the testator, meaning the person who is drafting a will, to give us direction during the subsistence of his life of how his assets must be distributed or who should be the beneficiaries or the heirs, as legally known, of his estate. So it also assists with establishing the different assets that the deceased person have, meaning it is beneficial in a way that in the event of the testator's death, the family of the deceased or the executor will not run around wondering what the deceased had during or what he acquired during his lifetime. If he has a will, he will directly state what his assets are and where they are kept in some instances. So it is beneficial in that it will assist the family of the deceased or the executor to know which assets to claim or to gather or to collect for the purposes of distributing. And one of the most beneficial reasons why a person should have a will is to identify the guardians of the minor children. In the event where the testator or the testatrix is a parent and his or her children are still below age, you will agree with me that at this point, the children will not know the affairs of their parents. As such, leaving a will assist in directing who should have custody of the children or who should raise the children, and it will make things less cumbersome on the family as to who takes care of the children and who looks after the children and who cares for their upbringing. And then one of the important reasons why one should have a will during the subsistence of their lives is so that their assets do not vest in people whom they were not so fond of. Imagine, for instance, if you are not on good terms with your sister, and if you die intestate, meaning if you die without leaving a will, then your sister, whom you were so not fond of, will get part of your assets. So it is beneficial for one to draft a will during the subsistence of their lives so that their assets would go to those people that they wish would benefit from their estate, meaning who would inherit from their estate. All right. What should be included in a will? We need to establish what is it that a testator or a testatrix should include in their will. A few clauses are worthy of note. These are the clauses that it is not advisable not to include in the will, but it's highly advisable that you incorporate in a will. The first clause that should be in the will is the heading. The heading, it entails the name of the testator or the testatrix, the ID number, of the testator or the testatrix so that we can know who this will specifically belongs to, so that we're not confused. If my name is Ntsoaki Queen Mokhele, you might find out that there are 5 other Ntsoaki Queen Mokheles in South Africa. So there will be confusion as to who this Ntsoaki Queen Mokhele is. So it is advisable that you include the full names of the deceased as they appear in his or her identity book and the ID number, so as that we are not confused. And then what follows is the revocation clause, meaning if you had drafted wills before, to avoid confusion in the event of your death and you are drafting a new one, you need to revoke the past wills that you have drafted to say, these ones do no longer apply, but this specific one applies as my last wishes. Remember, guys, a will is the last wish of the deceased. So it is important to revoke the past ones and present this one as your last will. The other important thing that will also make it less strenuous on your family to know where to go or what to do or where to start is to nominate or appoint an executor. This is where you need to appoint somebody who will take over your assets in the event of your death, meaning somebody who will step into your shoes to run your affairs. An executor basically means somebody who will have the authority to collect your assets, to entertain the liabilities or the claims that come through, and to take care of the distribution of your estate or your inheritance. So it is important for one to nominate an executor. It can either be a bank. Normally, it is safe to nominate a bank because everybody would know where you bank, mostly your family members. So upon learning about your death, the bank will automatically notify the master of the High Court that the specific person left a will, and they will present it to the master. So it is beneficial to nominate banks, or in the event where you have an attorney on your payroll, you can nominate your attorney, but nothing prevents you from appointing either your family member or your children as a testator or a testatrix. So that clause is really important to include in your will. And on this point, you also need to make a mention of what must happen to the professional fee, meaning when you appoint somebody as an executor, he or she is entitled to a certain fee for the administration of your estate. You also need to give a direction as to what must happen to security. Security basically entails the money or the security or confirmation that an executor has to file with the Master of High Court to say that should the executor misappropriate funds, the heirs of this specific estate will have recourse, and there will be a fund or an insurance that will make good the misappropriation of funds. So in your will, or whenever you're drafting a will with a professional, or whenever you're drafting it by yourself, you need to include a clause for professional fee and security to direct as to whether the master must request security or not. In most instances, most people will say the master must not request security for appointment. This is not advisable, as anybody is susceptible to misappropriating funds. We know how money is the root of all evil, and people get tempted to get their hands dirty when it comes to money. So it will be advisable that you make a strict rule that the master requests security, just so you safeguard the interests of your heirs. And then it is also important to make a provision for a substitute or alternative executor. This is where you make provision that should the appointed executor, be it your family member or maybe your attorney or accountant, wishes or is unwilling to take the estate or to administer the estate, then you know that you have somebody in line who will take over the estate. Because in such an instance, then your family will be stranded as to who they appoint as an executor. So it is advisable that you make a substitute or an alternative executor. In most instances, you find that when the banks learn that the estate does not have that much money, they decide not to proceed with administration and they renounce, meaning they write to the master to say, we are not willing to proceed with this estate. And then it becomes a problem or a challenge for the family members or the heirs to appoint an executor who is suitable. So it is important that you appoint somebody whom you can really trust, and you outline in your will who this person is in the event where maybe your bank or your attorney decides to renounce. And then the most important part of a will is appointing or nominating or doing a bequeathal. It's normally known as a bequeathal. This is where you appoint your heirs, meaning who should receive a benefit from your estate. You name them by their full names, and then you specifically indicate what they must receive from your will. Meaning, this is where you identify all your assets, as mentioned earlier, that you can, by drafting a will, you are in a position to identify your assets. This is where you break down who should receive what in the event of your death. So nominate your heirs very carefully and be very clear as to who gets what. We have come across wills where they just generalize to say, I leave my estate to my children in equal shares. So that causes a bit of a confusion because now we don't know where to start looking. So it is really important for you to identify your different assets and who they must go to, or who they must vest to. So that is why it's advisable that when you draft a will, you must make it a habit to keep on updating it, because as time goes on, you keep accumulating more assets. So to avoid dying partially testate and partially intestate, meaning the assets that you did not leave or did not make provision for in your will be treated as though you did not make wishes on those assets, unless you make a fine print at the end of your bequeathal to say that the residue of your estate should vest in a certain person. So guys, when you are drafting your will, please be mindful, as we don't have time to keep updating our wills year or each year or whenever you acquire a new asset, to make that fine print to say the residue of my estate should vest to a certain person. There's also a provision that you can make in a will of legacies. Legacies is where you give an indication that a certain portion of money from your assets should be paid to a certain person for a specific period. So in addition to appointing your heirs, you appoint your legacies or your legatees, who then will have the first preference as opposed to your heirs. The heirs get the residue of your estate, meaning the balance available for distribution only vests to them after all the liabilities have been paid. It vests to them after all the legatees have been paid. So let's say, for an example, you have a block of flats and you have an auntie or an aunt who is incapacitated, and you've been taking care of this aunt during the subsistence of your life. And you don't want to name her as an heir in your will. You can make provision that from this block of flats, or from the income generated from this block of flats, she gets maintenance of so much money until the such time that she passes on. So your auntie will be named as a legatee and not as an heir in your estate. With heirs, it is important to make provision for simultaneous death. We don't know who's going to die first when we're making our will. So you must make provision that it might be possible that you, as the testator or the testatrix, you die at the same time with your heirs. So you need to make provision as to what must happen to your estate in the event where you die at the same time with your nominated heirs. Normally, this is done by making representation. Representation entails that you give out a direction as to, I bequeath, for an example, I bequeath my estate to A, but should A die at the same time with me, my estate should go to B. So it is really important, as we do not know who's going to outlive who, or whether we're going to die at the same time. So it is important to make such a provision that should this event occur, then my estate should vest in a certain person. Okay. And then a will is also beneficial in that you can benefit somebody who is not necessarily an heir, but somebody we call a usufruct holder or a fideicommis holder. This entails where a deceased person makes provision for a certain person, normally spouses married in community of property, or maybe sometimes out of community of property, that the spouse continues to reside at the shared home and that the inheritance does not vest in the nominated heirs until such time that this spouse is deceased. So it's a way of protecting the surviving spouse's right or any other person. It can be the deceased person's mother to say, I'm not giving this house to my mother, but I want her to stay at this specific house until such time that she passes on. This then will protect this individual from being thrown on the streets, because we know once somebody passes on, there's always family feud, there's always this and that. So this person will be protected until such time that he or she passes on. And in addition to usufruct, there's also habitio or usus, meaning that you give a certain person to reside at the place until a certain occurrence or until a specific time, or you give somebody the right to enjoy the fruits of, for an example, let's say a farm. For somebody to keep farming on your farm until a certain occurrence takes place. So you must be very clear as to what the occurrence is that will stop the habitio or the usus. So this person will enjoy uninterrupted stay at this place or uninterrupted use at this place for as long as they keep it or maintain it in its original form. Meaning that they cannot destroy the place, meaning that they cannot dispose of the place, but they can enjoy the fruits of the place, or they can reside at the place until a certain occurrence. In most cases is where the deceased person's children are still minors. Obviously, minor children cannot take care of a fixed property or, let's say, a farm or a house. So you give a certain person the right to stay there and look after that house until this minor child attains the age of majority. The most important part, which is my favorite, is the exclusion of marriages in community of property and marriage out of community of property where there's an approval. So guys, you normally come across instances where the makoti or the son-in-law now has to benefit from the estate of his or her in-laws. To protect your inheritance as a testator or a testatrix from these marriages, or from the son-in-law or daughter-in-law now having to benefit from your estate, is to include this exclusionary clause of marriages. In this clause, you specifically state that this inheritance is not to form part of any past, present, or future marriages. So your children will marry, remarry, or get married in the future, but whenever their marriages are dissolved, meaning whenever they go through a divorce, your estate, meaning your legacy, will be protected from forming part of community of property of those marriages, or from the daughters-in-laws or the son-in-laws having a share in your property. So this is my favorite clause, and I feel that it benefits more people in that whoever who marries in the family will live without having their hands or getting their hands to your legacy as a testator or a testatrix. The other clause that you can include is collation, to say that whatever your children benefited or received from you during the subsistence of your life is not to form part of their inheritance. So if shortly before your death, you give your son your vintage Mercedes-Benz, the other heirs will not come to say, but you have already benefited so much. So you can include this clause, the collation, to protect your kids from being disadvantaged in a way that if you benefit them or if you give them gifts during the subsistence of your life, it can be construed as having received their part of the inheritance. And then you need to make provision for the remuneration of the executor. In terms of the Administration of Estates Act, an executor is entitled to no more than 3.5% of the total value of the estate. The emphasis is not more than 3.5%. So whenever you have appointed an executor, whether it's testate or whenever you've died intestate, the executor is not entitled to charge for their administration services not more than 3.5%. However, if the testator is an accountant or an attorney, they are entitled to charge their professional fees. Let's say, for an example, the testator is both a conveyancer and an attorney. And in the event of the administration or in the process of the administration, they have to do transfer of the fixed property, meaning the house, or they have to attend to your filing with SARS in the instance of an accountant. Those are professional services rendered to the estate. So they must get their professional fee from the estate for performing such duties in addition to the 3.5% executor's fee. Instead of just being silent on this, the executor needs to state in their will that the appointed executor, if it's an attorney or an accountant, is entitled to such a fee. You will note that sometimes estates or the executor is being sued in the court of law. It's not necessarily the executor who is being sued, but the estate. Let's say, for an example, the deceased person had a mortgage bond with ABSA, FNB, or Nedbank, whatever the case might be, and there's a dispute as to the outstanding balance, or maybe the deceased person was in arrears shortly before he passed on. It means that the executor, if he or she is an attorney, will have to attend to such a civil suit. So it means that he will take time off from the administration and tap into the litigation part of his profession to resolve whatever matter that the bank might have with the estate. So for such services, he's entitled to a certain fee. So from what I've just mentioned, you'll understand that additional fees can be only for attorneys and for accountants in the process of giving their legal or their professional services. So it is currently kept at 3.5%. So whenever you have an executor or your beneficiaries or your heirs are dealing with an executor, if such an executor charges or takes a fee of more than 3.5%, that's illegal, and you can report such an executor to the Master of High Court. I must just mention that all of these provisions are provided for by the Wills Act 7 of 1953 as amended. It was amended in 1992. The Wills Act, after the amendment, it was a bit relaxed as opposed to prior to 1992, where everything was a hard and fast rule. The one other provision or clause that can be included is what should happen or how the deceased should be buried, meaning funeral arrangements. You can make provision in your will that should you be incapacitated to exercise your own discretion or make your own decisions, maybe if the deceased person is involved in a car accident and he is incapable of making decisions for himself, this is where you can give directions as to whether they should keep you on life support or whether they should switch off the life support. And you can also make provision as to whether what must happen to your organs. You can choose to donate them. Normally, it's known as a living will, to say what should happen to your body or what should happen when a question of whether to keep you alive on life support arises. And you can also give provision under funeral arrangements as to whether you should be cremated, where you should be buried, who must be present and who mustn't be there. So if there are people that you don't want at your funeral, you can exclude them in your will to say, I don't want these people to be around when I'm being buried. All right. And the most important one, also an optional one that I fully support, that I feel that it is safe to have, is a testamentary trust. This is a trust that a testator creates in his or her will The benefit of this testamentary trust is that the tax is a bit lower as compared to a normal trust, and it will not be taxed during the subsistence of the deceased. It will only come into effect after the passing of the deceased. And the most important benefit of having a testamentary trust in your will is that the money will not be paid to the guardian fund, where it's a long process for the beneficiaries to get hold of the funds, especially the minor heirs. In this instance, instead of paying the money over to the guardian fund, where the guardian of the children of the deceased will now have to approach the master with proof of payment of where the money comes from to claim the money, that will only be paid quarterly in a year. This is where the trustees appointed by the executor, obviously it will be the people that the testator trusts, will then attend to the day-to-day care of the surviving children, mostly minor heirs, meaning that your children will not struggle to get an allowance monthly. It also means that the trustees will have to make the money in the trust to grow, meaning they'll have to invest it. So it won't be a stagnant amount that is accruing little interest, but they will make it grow in that it lasts for longer and it benefits the beneficiaries for longer. And then the other advantage is that the trustees, who are normally professional people, you can appoint anybody as a trustee, but it's advisable to appoint professional people as trustees, will manage the funds of a trust. So basically this clause in a will take care of your minor children way better than having the money paid over to the guardian fund. The other advantage is that the guardian fund is only in the capitals of each province, meaning in the Free State, it's only in the Bloemfontein region. And say, for instance, the minor children are based in Untitled, and there's no direct person that can assist them as and when they need assistance. So having a testamentary trust and trustees will be beneficial to your surviving children or your heirs, in that they will have a direct person who keeps checking on them, who knows of all the expenses that are involved in raising them. So it is really advisable to have a testamentary trust, more so if you have minor children. So in this instance, I will advise you to appoint a professional, either an attorney or an accountant. The reason I keep referring to an attorney and accountant is that these two professionals are insured in the instance where they misappropriate funds. So should they steal the money or misappropriate the money, then your beneficiaries or your heirs will have recourse against a fund that regulates or that insures these two professionals. Your will must be signed and it must be dated, so not to cause confusion as to what is your last will. The Amending Act has relaxed this formality or requirement that it must be dated, but just to avoid confusion and just so that whoever who is dealing with your estate ends up being in a position where they don't know which will to present to the master, it is advisable that you date your will. And then we're going to get to the formalities of a will. Formalities entailing that what do we regard as a valid will. First and foremost, the will must be in writing. It can be written by anybody. It can be written by a pen or it can be written on a computer and typed, as long as it's down in writing. And secondly, it must be signed by the testator or any other person in his presence and by his direction. For an example, if the testator or the testatrix is incapable of writing, maybe he or she is on her deathbed, or maybe he or she has both her limbs broken, they cannot sign, they can't even append a mark, they can get anybody to sign on their behalf, in their presence and on their direction. So if you cannot write, all is not lost. You can get anybody to write or to sign on your behalf after expressing your wishes. The signing of a will includes in the Amendment Act, which was not the position before, it includes making of a mark, making of initials, and getting any other person to sign on your behalf as the testator or the testatrix. However, it is important to note that should the testator have any other person sign on their behalf or sign by making a mark or with their thumbprint, that a commissioner of oaths must always, this is a hard and fast rule, that the commissioner of oaths commission such a will in the presence of both the person signing and the testator and the commissioner. They must be in the presence of each other. So we cannot have an instance where A drafts their will or has or initials or makes a mark or have somebody sign on their behalf, and then 3 days later we take it to somebody else to go commission it. All of this should be signed in the presence of each other, including the commissioner. Before the 1st of October 1992, in terms of the Wills Act that was not amended, only a signature was accepted as signing of a will. But the Amendment Act has relaxed rules, and the testator can sign by making a mark or by making initials. But in most instances, this kind of wills are normally contested, and they are normally taken to court, where the court will now come to a decision or a rebuttable decision that these are indeed the wishes of the deceased. So please make note of the wills that are drafted prior to the 1st of October 1992, before the amendment was made to the Act. In addition to signing or making a mark or having somebody to sign on the testator's behalf by his direction and in his presence, the will has to be witnessed by 2 competent witnesses in the presence of each other, at least 2. So there can be more than 2 witnesses. But all these witnesses signing the will must be in the presence of each other together with the testator. One thing that I do not agree with is that they need not know that they are signing a will. They just need to sign. I don't agree with that part of the law, but it is the position. They really do not need to know that they are signing the will. They must just sign a document that they saw the testator signing or making his thumbprint or making a mark or somebody making or signing on his behalf by his directions. And who can be a witness to a will? Any person who is 14 years of age or older, meaning any person who can give evidence in the court of law. So you can get somebody who is 14, 15, 16, not necessarily a measure, to sign or to witness a will. What is worthy of note is that with the Amending Act, it is not necessary for the witnesses to sign each page of the will. They can just sign the last page of the will. But it is incumbent on the testator to sign each and every page of the will, and for the commissioner to commission each and every page of the will in the event where the testator is signing by making a mark or having somebody to sign on their behalf by their direction. All of this, guys, please note that it must be done in the presence of each other, meaning the testator or the person signing by his direction in his presence and the witnesses must all sign in the presence of each other and the commissioner. So a picture that we get whenever a will is being signed is that everybody must be in a room. We normally have cases that are commissioned by the SAPS a month, 3 months, 6 months later after the signing of the testator and his or her witnesses. I have never come across a case where the High Court has accepted such a will. They reject them because the requirement is that all these people must be in the presence of each other. So if it's taken months later or days later, there can be foul play identified in such a signing or such a commissioning. And we normally get this in the event where the testator or the testatrix is an elderly person who was sickly at the time of making this will, So it raises eyebrows as to whether this was indeed his or her true wishes, whether he or she signed in the absence of a commissioner to certify that these are indeed the wishes of the testator or the signature of the testator. So guys, please be mindful that all of this must be done in the presence of all these parties involved. It is worthy to note that the commissioner, if commissioning a will have to sign each and every page with the testator unless the page where he or she makes his or her certificate. So the commissioner mustn't only sign at the end of the will or the last page of the will. He or she must sign each and every page. There's a case where a will was rejected because the commissioner did not identify himself as the commissioner of oaths, but identified himself as an attorney. So it is very strict that whoever who is commissioning the will must identify themselves as the commissioner of oaths. On the issue of signing a will by initials or by initials rather, there is a Verrington case. A Verrington case is where the court for the first time accepted a will that was not signed by a signature but rather by initials as a valid will. So I would advise you to sign with your signature so that we avoid confusion as to whether your initials are indeed your initials, because anybody can fake initials, but it's very difficult for people to fake a signature because now an expert will have to be called in and we can compare with your past signatures to see if indeed this is your signature as the testator. So from me, I feel that it's safe to use your signature instead of your initials when drafting a will. Please go read up whenever you have time, just for interest's sake, the Verrington case where initials were accepted. And you'll see that in some instances, the master would reject it and then the matter will be taken to High Court, where the court, after going through all the evidence, if they're not satisfied that these are indeed the last wishes of the deceased, can either give an order to say that this is indeed the wishes of the deceased or these are not the wishes of the deceased. So whenever you appoint an attorney or whenever you draft in your will as an individual, just make sure that everything is done precisely so that there's no confusion as to what your wishes are or what is it that you had hoped to happen to your estate. What then happens in the event where the master rejects a will, or in the event where the High Court agrees with the master that this cannot be considered a valid will? It means that we will move from testate succession, testate entailing that the deceased person left a valid will behind, to interstate succession. Interstate succession is where now the law, as it stands in South Africa, will now dictate who receives your estate. And we don't want that, because we want people that we want to benefit from our hard work and from our estates. And then who can be appointed as an executor? An executor is somebody who attends to the administration of your estate, meaning it's somebody who steps into your shoes to attend to all the affairs that you can no longer attend to, meaning it's somebody who collects your assets, who lodges claims on your behalf into your estate so that it can be distributed to your heirs. It's somebody who now has to deal with your creditors. Maybe you owed a bank, a personal loan, a credit card, any sort of debt. And also, in addition to your creditors, it's somebody who collects money that was due to you. Maybe from a neighbor whom you borrowed money, or from, let's say, maybe Road Accident Fund. There was money that was due to you from the Road Accident Fund. But it is important to note that the executor can do this in this instance of the Road Accident Fund if the case was at a stage that we call closing of pleadings. But if it was before closing of pleadings, there's no way that the executor can proceed with the claim, because now he wasn't involved in a car accident. He doesn't know what happened, and he cannot be in a position to attend to pleadings. However, if pleadings were closed, everything was done and put out, then he can proceed with such a claim, and the money will have to be paid to your estate as the person who initially instituted a claim against the estate. So basically, an executor is somebody who steps into your shoes and runs your affairs as though you are still alive. In addition to running your affairs, meaning collecting your assets and attending to your creditors and your debtors, they are also liable to attend to any possible maintenance claim that can come against you if you are still alive. So for instance, if you had a child who was dependent on you, your biological or adoptive child, then should the guardian of this child bring forward a maintenance claim, the executor will have to entertain such a claim and see to it that such a claim is paid. It is worthy to note that the most important claim against the estate, the one that takes preference, is one from SARS. We pay SARS even from our graves. That is why we have what we call estate duty. Estate duty is where, whether you died owing SARS, all is not forgotten, SARS will still come after you, and your estate will be liable to pay that. In addition to paying any assessment from SARS, but it doesn't necessarily mean that the executor will just pay. If there was something due to you and you passed on before you could claim it, then the executor will have to claim such money from SARS, and SARS will be liable to pay. So you will understand that the executor is basically you. He's attending to your affairs or seeing to it that money gets through to your children. He's paying off your debts. He's collecting all money that was due to you, meaning he steps into your shoes and run your affairs. So who can we appoint as an executor? You can appoint anybody you want, as long as that person has a capacity to administer the estate. We cannot appoint a child of, let's say, 13, 14 years, because that child will not know where to begin in the administration. So you need to be very careful who you appoint as your executor in your will. It is advisable that people appoint attorneys or accountants for the reasons I've mentioned earlier, that they are professionals that are insured against misappropriation of funds, meaning there's an indemnity insurance that is in place for these two professionals. So you can appoint, whether it's a family member, your children who are of age, or an accountant or an attorney. But remember what I said earlier, guys, that it is always advisable to make a substitute or an alternative executor. Should they not be willing to take over the estate, you know that you have somebody who will step in place. So this person who is an executor, the first thing when you pass on, I believe this is the person that you should tell, Jorge, I have a will stashed up somewhere, so that when you die, people wouldn't think that you died without leaving a will. I mentioned earlier that it is safer to do your wills with banks. You might have a will with your attorney, but his office might close down, maybe because he died, or maybe because maybe he went bankrupt and nobody would know that there was a will. So in my opinion, it is safer to draft your wills with banks, because everybody in your family would know where you were banking. And the bank, upon learning about your death, banks have been here for generations and generations. They would then submit the letters, the will to the master, and they will express to the master whether they are willing to administer the estate or not. It is also advisable that you inform your family members or your children that I have a will. Maybe it is safely kept with an attorney or with a bank, or maybe hand them a key to say, when I die, this is a key where my will is left. But just tell maybe 2 or 3 people that you have a will somewhere, because if you don't tell anybody and you didn't file your will with your bank, then nobody would know that you actually left a will behind. And this is where I normally advise clients, be it a friend, if maybe you don't trust your family members, because we know how our family members, they might just kill you, knowing that there's something to gain from that. So just tell somebody that you have a will, it is safely kept somewhere. There was a question of whether one can both be a witness to a will and be an heir to a will. or in a will? The answer is yes with the new act. But previously you couldn't be both a witness and an heir to a will. But remember, the requirement is that, or the formality is that, the will must be signed by at least 2 witnesses. So you cannot be an heir and a witness if the will is only signed by 2 witnesses, meaning it will just be you and the other witness. Meaning that an inference can be drawn that you exercised undue influence to the testator. So you can only be an heir and a witness to a will if a will is signed by more than 2 witnesses. So it mustn't just be you and the other witness. Please note of that, guys. And then another question was asked of whether can you draft the will on behalf of the deceased and be a beneficiary to such a will or an heir to such a will. It's a tricky one. Let's say I'm an attorney. I have a good relationship with my client for over 30 years. And my client decides, Queen, you've been so good to me. We've been through it all, me and you. And I want to leave something for you in addition to the 3.5% that you're going to get as my executor and as somebody who's drafting a will. Then if the testator appoints you, the person who's drafting a will, both an executor and somebody who drafted it and somebody who's going to benefit from it, it's a tricky one because an inference can be drawn that you exercised undue influence, meaning you somehow dictated or somehow applied undue influence on the testator to benefit you. Anybody can come forth to dispute as to whether those are indeed the wishes of the deceased. And this can be taken to court for interpretation or for the court to decide whether there was any undue influence exercised or not. Then remember, guys, the purpose of the witnesses. This is where the witnesses will come forth. If everything is being signed in the presence of each other, they can tell to say, hi, the testator or the testatrix was behaving rather abnormally on that day. She seemed scared. She seemed uncertain. So I wouldn't advise that you draft the will and you are the appointed executor and you both an heir in it, because it can cause problems later on in life or when the administration has to take place and the inheritance or the distribution has to be done. Please be advised further that the Wills Week will be from the 26th of October 2020 to the 30th of October 2020. For more information, please visit the Legal Aid website or our social media accounts on Facebook and on Twitter. And if you need more clarity on this presentation, please call the Legal Aid Advice Line on 0800 110 110 or send a please call to 079 835 7179. Thank you for listening. Bye.